Yes, Your Honor. We were here about 2 weeks ago for the initial sentencing date. And what a difference 2 weeks, I think, makes here. I think many of the prosecutor's points, not all of them, many of them I think are very well taken. And I think that it is accurate that when we were here 2 weeks ago, I don't think Ms. Ornette had recognized or accepted sort of the extent of her problem. I am happy to report to the court when I went and met with her in the jail afterwards, and as we prepared for this hearing, what I was hearing from her was very different. She openly acknowledged to me that she has a problem with alcohol. I mean, confided to me that that may have been the first time she was able to say that out loud, to really express it. She has expressed to me a desire to go into treatment and explore treatment. She's made contact with Bear River. This is a very unique case for us in the sense of we have somebody who presents here with no prior history, no history. And I mean, no prior felonies, no prior misdemeanors prior to this point. And then we have an offense that is, frankly, a pretty serious offense, more serious than we see most people, again, on what will be a true first offense. I think there is some unpacking that needs to be done here. I'm happy to hear from Ms. Cornett that she is wanting to seek treatment. I think we probably need to have an assessment done to figure out what the right level of treatment for her is going to be. But I think that is a very encouraging development that's happened in the last 2 weeks. And frankly, I don't know that happens if we don't sort of have the events that lead to it, which frankly are kind of, I think, a blessing in disguise that she was able to make that recognition. With that in mind, I think the court has to balance a few things in crafting a sentence here. And the first of which is, again, true first offense, but on the other hand, we have an offense that, again, I think is more sort of shocking and more serious than our typical offense. So the court has to balance, where do we fall on this? There's probably a punishment element, but I think certainly a rehabilitation element is an important element when we're looking at someone, again, Ms. Cornett's stage of life who really has no prior history. We have to balance those things. And certainly we have to balance the impact that this has had on the victim and the victim's family. I think for the court, I would suggest that a sentence here that focuses on rehabilitation is the appropriate goals here. I would suggest to the court there's a few different ways I think the court could address that. I spoke to Ms. Cornett. She would be willing and actually is interested in the court placing her on a tether if the court were to allow for her to be released from the jail. I think that would be a good step for her. She's also expressed to me she does have employment. So if the court were to allow her to partake in the work camp program, participate in that, she has a job that she could go back to. The work camp program, I do think, has benefits that would be specifically beneficial in this case. Specifically, she would be tested every day, meaning, as opposed to even sort of a regular probationary term where she wouldn't be tested every day. If she were in the work camp program, she would be tested and held accountable every day. And if she relapses and uses, she's going to go right back into the jail. So I think that there are tools the court has here in terms of what we can do to craft a sentence that has both a punishment element to it, but also focuses on the goals of rehabilitation. Thank you.
Thank you, Ms. Cornett. Anything you wanted to say today?
Sure. First, I would like to apologize to Hayden and his family. My actions and lack of action that night were inexcusable. I'm so sorry for the pain that I caused, and I wish that your family didn't have to live through that pain. I wish I could go back and do the right thing for you, and I will forever be sorry for this. Your Honor, I also want to apologize for the state that I was in the last time that I was here. I was drinking the night before, and I do understand why you made the decision that you made that day. But along with my apology, I also want to thank you for making that decision. Even though in that moment I was confused, scared, and angry, I have to say thank you because you helped me. My head is more clear and I'm thinking straighter than I have in a long time. While I was away, I met a woman who I became friends with. And this woman is coming to the end of a very long sentence due to repeat offenses. She opened my eyes as to where the road I've been taking the last 5 months will lead, should I continue on it. I attended the women's group, which helped me open up and be honest about my issues and my alcohol abuse. It also helped me realize that it's not too late to change. Last Friday, I was able to speak with a therapist from Bear River and get information about treatment programs. I know that people don't change overnight, but I have started to change. I've never been one to ask for help, and I realize now that I need help, and it's getting easier to ask. I have 5 kids who I need to mend relationships with. I am so proud of the people that they have become and are becoming. And I was always proud of my role in helping them become these people. While I'm still so proud of them, I'm no longer proud of myself. I want to be able to be proud of being a mom again. I am so sick of being a disappointment to them, and I want to do better. Along with all of this, in January, I was hired by Dollar General to be the store manager, and they're waiting for me to let them know when I can start. My parents instilled a very strong work ethic in me from a young age, and I am excited and hopeful about this opportunity. I'm extremely serious about my recovery and the recovery of my life, and I'm willing to do whatever it takes to ensure this. Thank you.
All right, thank you. Ms. Cornett, I did read through the report. I'm familiar with what happened in this case. There's also a lot of information in that report about you and your circumstances and your background. I take all of that into consideration. I certainly take the victim's statements into consideration. That's something that's important for the court to recognize the effect that the crime has had on the young man in this case and his health and problems that he's going to have going forward because of this injury. And the effect that it's had on their family generally. These things don't happen in a vacuum. And when you're the victim of a crime, it creates all kinds of issues in terms of feeling safe, feeling secure. And that's aside from just dealing with an injured child and the medical appointments and concern over the long-term effects and how it's going to affect his life. So their statements certainly have an impact. I've listened carefully to what the lawyers have each had to say, and of course what you've had to say here today. That's important to me. And I think that it is certainly promising that you're starting to kind of get a different perspective on the way things were going. I think it's clear from your statements and actions leading up to your last appearance in court, at least, that you did not fully see the other side of this. And I think that's in large part due to your use of alcohol and marijuana and other substances, perhaps. When you're in the middle of that, you can't really see what everybody else sees looking at it from the outside. And, you know, your actions around this crime, using marijuana and driving, and then saying, well, it doesn't really affect me. Well, if it doesn't affect you, why are you using it? The whole reason why people use marijuana is because it alters their mental and physical state. It makes them feel better, makes them feel different. And so it doesn't make any sense to say I'm using marijuana, but it doesn't affect me. And clearly, you know, you were using alcohol. I know your statement was that you started drinking after the accident happened because you were upset. Given the full development of everything that's happened during this case, I don't believe that either. firmly convinced that you were using alcohol before you were driving. And that and the marijuana contributed both to the accident and the injury of this young man and to your actions in leaving the scene, all of which complicated this and puts you in a worse position. Certainly delayed the help that the young man could have gotten and should have gotten. That being said, you don't have a prior record. It sounds like you want to take steps to address what you now see as a problem. And so the court has to take those things into consideration along with the negative aspects. And I think a sentence that combines some punishment so that you understand that this was wrongful conduct, that it doesn't just go away, that there are other people who are going to feel long-term effects as a result of this. And so it's right that you feel some effects as a result of this. I also think that providing for probation to monitor you once you are released from jail is important for us as a community to make sure that once you get on the right track, that you're staying on the right track so that you're not presenting a danger to other people by using marijuana or alcohol. And then I think the allowance for rehabilitation is also important because you don't have a prior record. I think you've demonstrated that you can conform to what we all expect and that you can get back to that and move on from this and not present a danger to other people. So I think it's important for the sentence to try to incorporate all of those elements. So in that regard, first of all, the court is going to place you on probation for a period of 18 months. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. And that includes, of course, that you not use alcohol, that you not possess alcoholic beverages or other intoxicants, that you not use or possess any controlled substances or drug paraphernalia unless they are medications that are prescribed to you, that you complete any outpatient or residential substance abuse treatment that's referred to you by your probation agent, and all the other terms and conditions of the probation. The court is going to order that you serve 9 months in the Otsego County Jail. The court is going to require that you serve 6 months of that up front. I would allow you to be released for the remaining 90 days if you are able to get a bed and go into residential treatment. So I would allow you to leave jail for the purpose of attending a residential treatment program only. That's a 30-day program, 60-day program, whatever it is. If you successfully complete that program, then the court would give you jail credit for that program off your sentence. And whatever would be remaining of that final 90 days would be held in abeyance. So again, 9 months in the Otsego County Jail, the first 6 months will be served up front with release to residential treatment if eligible for the last 90 days. If you're not able to get into a residential treatment program, then you would just have to serve that final 90 days in jail. Do you have credit for, what was the date of our last hearing?
Should be 17 days total, so 15 additional days.
Okay, so you do have credit for 17 days served. The court is also going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60, and a $68 state cost, as well as a $30 supervision fee per month while you're on probation. You do have the ability to seek an appeal of the sentence, and Mr. Trush, if you can have Ms. Cornett down with receipt of her appellate rights.
Yes, sir.
Judge, is the court going to make a finding on the record as to restitution to the victim?
Thank you. That wasn't in there. The court is going to leave the matter of restitution open. Mr. Rolla, as you're aware, the people have the obligation of supporting the request for amounts for restitution. So I'll leave that open to the extent there is restitution. I think certainly it would be appropriate in this case, and the court will order it. You'll just need to notify counsel if there's an objection, then you would need to notice that for hearing so the court can take evidence as to the amount.
And that's fine, Judge. We're awaiting some additional documentation. So restitution is preserved.
Yes.
Thank you, Your Honor.
All right, has Ms. Burnett received her rebuttal rights?
She has initialed and dated acknowledging she's received them. I'm tendering that back to the court.
All right, thank you, Ms. Burnett. You are remanded to the custody of
Your Honor, does the court want me to prepare an order in regards to the rehab treatment?
I made as part of the jail worksheet, they're aware that she is eligible to be released after 6 months to treatment. Once we get to that point, we may need, in order if she's able to get that and get into treatment.
Understood.
Your Honor, would I be able to hug my husband before I go back?
I'm sorry, no.
Love you.
Me too.
Mr. Roll, I believe that's the end
End
of
of the docket. I hope so, Judge.
All right, the court will be in recess until 1:30. This is file number 266954. If I could have counsel put your appearances on.
John, my call that people.
Good afternoon, Judge. John Steffi on behalf of the defendant. We're both here before you at our first status conference.
Okay. Mr. Steffi, can you tell me the status of this file here today?
Thank you, Judge. We did run a prelim in this case. I'm waiting on the transcript to be prepared. So I was going to ask Your Honor for another status conference date. I would think at that point, we'll have a pretty good idea of if we're going to need a trial date or not.
Okay. Mr. Rolla?
As far as the length of trial, Judge?
No, I'm just, do you have an objection to an adjournment?
Oh, I'm sorry, Judge. No, Your Honor, I do not.
Okay. And Mr. Steffi, you said 30 days?
I think that should be good, yes.
I want to avoid coming back and then having to adjourn for another.
I as well.
days,
So maybe if we could do 45 minutes, that would be more prudent. My person I used to do transcripts does not work with this court anymore, so it's been a little bit of a hiccup, but we're figuring it out.
Okay, so we'll set it for a status conference, plea hearing in 45 days. So that would be the court mid-April motion day. And if we don't have a plea at that time, then the court will schedule it, get it on the trial docket.
Great.
Mr. Steffi, anything further from your side?
No, thank you.
Mr. Rolla?
No, Your Honor, thank you.
Ms. Haythaler, do you have any questions at all about how we're going to proceed with your case?
No, sir.
Okay, thank you. That's all for today.
Thanks, Judge. Have a great day.
Mr. Dick, do you have either of your clients ready?
Yes, Your Honor, Ms. Price.
Okay, we'll call People versus Carly Price, file number 256934 and 256946. The record should reflect Ms. Price is present here in the courtroom today. And Mr. Dick, can you tell me where things are at with this file?
Yes, Your Honor. So today we were going to be entering a plea on both files. File that has possession of analogs.
So file number 256934, the charges are possession of analogs as habitual second, operating the suspended license as a second or subsequent.
Yes, thank you, Your Honor. On that matter, we would be entering a plea of guilty to possession of analogs in exchange for dismissal of the second count and all enhancements.
Mr. Roll, is that correct?
This was which file, Judge?
6934.
6934. Would be count one, possession of analogs, dismissal of count two, as well as the additional offender.
And the drug double enhancement as well.
Yes, Your Honor. All enhancements.
And then as to file 6946,
A plea of guilty will be entered to counts 1 and 3.
Correct.
Dismissal of the remaining counts and any.
And all enhancements, additional 4.
okay. Okay, Ms. Price, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes, sir.
All right, and what you've discussed with him is that the same as what we've discussed here today?
Yes, sir.
Is that how you wanted to proceed?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Price, are you currently on any kind of probation or parole?
No.
All right, and you understand that by pleading guilty to possession of analogs, in this case, amphetamines, that the maximum penalty you could face would be up to 2 years and or a $2,000 fine,
Yes, sir.
and that the maximum possible penalty for delivery or manufacture of methamphetamine is up to 20 years and or a $25,000 fine,
Yes, sir.
and using using a computer or the internet to commit a crime carries with it a maximum penalty of up to 2 years and or a $5,000 fine. You understand that?
Yes, Your Honor.
Mr. Dick, are you aware of any discretionary or mandatory consecutive sentencing sanctions in this case?
The only ones that are discretionary would be the ones with the methamphetamine and using computer.
Okay, was Ms. Price on bond during those, or is that the basis for the discretionary consecutive?
No, Your Honor.
So Ms. Price, with all of those penalties that I've just indicated to you in mind, what is your plea to each of those charges today?
I was guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty, and you won't have them anymore.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty to these crimes because you are actually guilty of each of these crimes?
Yes.
So looking at file 6934 first, this indicates that happened around July 20th of 2025. Is that the correct time frame?
Yes, Your Honor.
At that time, were you present in Otsego County?
Yes, Your Honor.
Did you have possession of some amphetamines at that time?
Yes.
Did you know that that's what those substances were?
Yes, I did.
Did you have any legal right to have possession of any of those?
No.
And then the other case, the date I have on that is July 7th of 2025. Is that the correct date?
Yes.
And were you also in Otsego County at that time?
Yes, I was.
Did you have possession of some methamphetamine at that time?
Yes, I did.
Did you give or sell that substance to another person?
Yes.
Did you have any legal right to do that?
No.
And did you use a computer or the internet to communicate with another individual for the purpose of selling that or delivering that substance?
I did.
And that also occurred here in Otsego County?
Yes.
Mr. Rolla, are the people satisfied with the factual basis as to all three charges?
Yes, Your Honor, thank you.
Mr. Dick?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
My people, thank you.
Thank you, Your Honor.
Are you both counsel, are you both satisfied that this court has complied with statute and court will in taking of this plea?
Yes, Judge.
Yes, Your Honor.
Ms. Price, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to all three. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. You're going to meet with Ms. Davis before you leave here today to set up a time for a pre-sentence interview. And then you'll have an opportunity to go through that report with your attorney prior to the sentencing hearing. Mr. Rolla, anything further on these files today?
Not in this matter, no, Judge. Thank you.
Mr. Dick?
No, Your Honor.
Ms. Price, do you have any questions about how we're going to go forward?
No, Your Honor.
Okay, thank you. That's all for today. And Mr. Dick, have you had any contact with Mr. Robbins?
He is currently in the Roscommon County Jail.
That's where. Written there.
I was just looking, I don't see them right offhand, but let me look in my email from.
We'll call People versus Robbins, file number 266956. Counselor present, Mr. Robbins is not. This hearing was set for 2 o'clock. It's now 2:11. I do believe. Doc, it does indicate that he might be still lodged in Roscommon. Do you know if that's the case for
It
sure?
is.
It is, okay.
Yes.
Kyle Robin.
I don't see a writ prepared, so I think.
I don't think my office was notified that he was there. I think that was. the problem.
I do have an email from Misty.
Oh, wait, Roscommon's connecting.
Okay,
Ah, there you go.
Mr. Trish, can you tell me the status of this file?
Yes, thank you, Your Honor. In this file, we're going to be asking for a 30-day adjournment here. We've been in negotiations with the prosecutor. There is a global offer that contemplates resolving a couple misdemeanor matters as well as this. We're not quite there yet, but I would say we're most of the way there. Might not be in the same row, but we're certainly in the same section of the stadium, so to speak. And again, I think with 30 more days, we likely would be able to get it done. I would like to address a bond issue to the court, though, as well.
Okay, what is the bond request?
Your Honor, I think the bond is set in this matter at $50,000 cash or surety. I would ask the court to consider a slight reduction here. Mr. Roby has been accepted into the Lion's Den program for treatment. He is working on getting his bond posted here, and the $50,000 bond is an impediment to that. I would suggest to the court, even if we reduced it to a $30,000 cash or surety bond, I think he would likely be able to make that. And again, I think that's still a significant bond that would give him a significant incentive to appear for court and do the things he's supposed to do. Additionally, keeping in mind, the court could put a condition into the bond, for the treatment program, which would give an additional sort of layer of sort of supervision or protection to the court. Thank you.
Mr. Trush, based on what you think at this point would be a likely, if there is a plea agreement, what would be a likely guideline range? Have you looked at that?
So I have, Your Honor, and that's part of what we're working on is clearing up some of the prior history. It's likely going to be either a straddle cell. So I've had it come out at 5 to 23 or 10 to 23 based on the some different scoring factors. I think it could come out as high as and I'm sorry, I don't have the book in front of me, but the low end could come out as high as 19, again, depending on some of those scoring factors. Again, with the anticipated or the offer as it stands right now.
All right, thank you. Ms. Koch, first of all, do you have any objection to the adjournment for 30 days?
No, but I will pull the plea offer at the next hearing.
Okay, and then in terms of the bond modification?
Yeah, I think the bond is appropriately sent. That Mr. Roby had a domestic violence case when this case happened. I believe he was on bond. Mr. Trush can correct me if I have the order of the cases wrong. It was a pretty violent criminal act according to the police report. I can read what the police report said, but it was bad. The victim wants the defendant to get help, but he has a pretty lengthy criminal history, includes a 2006 felony BE, 2010 DWLS, a 2010 marijuana, a 2010 negligent homicide, a 2019 DWLS, a 2019 DWLS, and a 2019 possession of methamphetamine. I pulled his PRVs on his last Ross Common felony case, and they were 70. So I expect the guidelines to be fairly high. The offer is assault by strangulation, domestic violence, dismiss the aggravated stalking and habituals, dismiss the other DV, and dismiss the DWLS.
Okay. All right. So, I mean, Mr. Roby, if the only reason for the modification of bond is so that you can get out and go to compliance, then I'm not opposed to treatment, but it sounds like your guidelines are going to score out at a minimum for some jail time. Okay. It doesn't make sense to me to have you be released, go into the lion's den for a month, and then be sentenced to jail and have to leave that program.
Actually, sir, there's a bond that is revoked right now that we actually needed reinstated, was actually what he was supposed to ask you about. And we sat down yesterday with my lien file. And
Mr. Roby, the bond that's revoked is the district court bond that we have to address Tuesday. I plan to come over and talk to you about that today, but that's up in front of the court on Tuesday the 10th. So next Tuesday.
Oh, so we can't do anything about that till next week?
No, I stop you because I don't really want you to talk about our conversation.
Okay. Well, I didn't know about that, sir. I'm sorry you weren't here in person to talk about it. Okay, I'm sorry. Well, we discussed my lien file yesterday and looked through it, and it scored me out. He said he was confident in 5 to 23 months, which would be about a county year. I'm trying to go to the lion's den for minimum of a year. I have a really bad drinking problem, sir. I really, really want this help, and I need this help. You can look at my file. I have a problem with alcohol and drugs, sir. I have a problem. I need help. I really care about this individual that I hurt, and I can't keep going through life like this, sir. I cannot do this. I need help.
Yeah.
I have been accepted into the lion's den. They have a bed waiting for me. I have transportation there. I have the money that they want to seed money or whatever they want, like $65. I have that money set aside. Somebody's got it for me. I need this help, sir.
Yeah.
I have no intentions on walking away. I don't have any, and like, there's a blackout period where I don't get to contact anybody for like 3 months or 4 months or whatever, with exception, they bring me to my court dates. You know what I'm saying? There's no missing court dates. They're bringing me to my court dates. I need this help, sir. I really need this help. Honestly, you could say, all right, straight to the lion's den, and I have a vehicle pick me up and take me straight there today, and then there's no skipping around. Otherwise, it's me trying to make a bond next week, and then, okay, well, I got until sentencing to get there. Well, I'm not doing that, obviously. I'm just trying to go to the lion's den, sir. I very seriously need this help. I have a drinking problem. You weren't in here, Mr. McCall's like, damn, I didn't even notice you. I'm losing a lot of weight. I've been self-destruct for the last year. My grandmother died. The only person in my family that cared about. I've been in self-destruct mode. You heard Miss Cope. I hurt somebody that I really care about. I'm not doing good, sir. I really, really need this help.
Yeah.
Okay.
I'm not doubting that at all. The question is, when is the right time for you to get that help?
Well, that's
you have to answer for these charges first.
I understand,
then
sir.
we can move on to the treatment part of it, and it doesn't make sense to do those out of order to me. I'm not going to do those out of order.
Okay.
Once we get this taken care of, if you're going to have a jail sentence, you serve your jail time, and then you can go to treatment. The lines don't go anywhere. But you can't do the treatment and then the jail. Any treatment facility will tell you that that's counterproductive to go into treatment and then go back to jail.
Make the treatment part of my sentence.
Maybe. Yeah. But I'm not going to let you out of jail now by lowering your bond to go into treatment, have you come back, go back to jail.
Can you modify my bond to send me straight there? They will send a car to pick me up.
What I just said is, we're not going to have you go into treatment and then come back and then potentially serve a jail sentence.
Okay.
So it may be part of the sentence once we get to that point. If we have a plea,
Okay.
or if you're found guilty at a trial,
Okay.
then we can look at that as part of the sentencing. And I always do ask anybody, I'm not opposed to making treatment part of a sentence. It doesn't make sense to put the cart before the horse. So
I understand.
if that's the only reason for the modification bond, I'm going to deny that request. I'll absolutely consider Lyons then as part of your sentence if you're found guilty or you plead guilty.
Appreciate that, sir. I really need this help.
Okay. All right. So we're going to adjourn this for 30 days. Mr. Trush will be in touch with you, it sounds like, later today to talk about this case and your other case.
Thank you, sir.
You're Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Michael Belbot. Your Honor, I did speak with Mr. Belbot. It's my understanding he does wish to plead guilty to the probation violation. I spoke with Mr. McFalda. It's my understanding that he's going to have a recommendation of 12 months total. That Mr. Belbot has a bit of credit towards that and an unsuccessful discharge.
Mr. McFarland, can you leave a record of how much credit?
That's correct, Judge. He is 253 days served as of yesterday.
So, in terms of credit, Mr. McFalden, does that include the time in Wisconsin? Or should I address that with the court?
That does not include that time.
Okay, thank you.
Mr. Belbot, have you had a chance to talk to Mr. Thompson about this agreement?
Yes, sir.
Okay. And you understand what the recommended sentence is?
Yes, sir.
I'm likely to agree and go along with that.
Yes, sir.
Okay. So with that in mind, what is your plea to the probation violation?
Guilty as charged.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Mr. Belbot, you understand that you do have the right to have a hearing as to whether or not you violated your probation?
Yes.
And that by pleading guilty, you're going to be giving up that right?
Yes.
Also, even though we've discussed what the likely sentence would be, by pleading guilty, it could subject you to the maximum possible penalty on your underlying charge of OWI third, which is up to 5 years. Do you understand that?
Yes, I do.
And with all of that in mind, it's your intention to plead guilty today?
Yes, sir.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything other than what we've just talked about?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you did violate your probation?
Yes, I did.
Back on February 16th of 2026, were you on probation out of Crawford County?
Yes.
Were you aware that one of the conditions of your probation was that you were to not use or possess any alcohol?
Yes.
And did you use alcohol on that date?
Yes, I do.
All right, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation. The court will accept the guilty plea. And you don't have an objection to going forward with the sentencing here today?
Yes, please.
That's correct, Your Honor. It's our request to do immediate sentencing and to waive our right to updated PSI.
Okay. Mr. McFarland, other than what you've already stated, do you have anything you'd like to state in terms of his performance on probation or sentencing?
No objection.
Ms. Coe?
No.
Mr. Thompson?
Your Honor, I would ask the court to consider the time he's already served. In addition, Mr. Belbot can address this, but he advises me he did approximately 5 days in Wisconsin when he first violated before he was transported here. He's asking the court to credit that. I think Mr. McFall's recommendation is appropriate. Mr. Belbot had a relapse. He has recognized that relapse. I think he's going to address the court about how he understands this is a further reminder he needs to work his program. He had some upsetting life events, broke up with a long-term partner. He didn't handle it correctly. He understands that now with some reflection, they shouldn't have turned to alcohol. He didn't drive here, which I think is a point in his favor. And obviously we got here because of a driving offense. He did use alcohol. He's very apologetic about that, but this could have been worse and he didn't drive. So ask the court to take all that into consideration. Thank you.
Thank you. you. Mr. Velbat, anything you wanted to say today?
No, sir.
I did have a chance to review your file prior to the hearing today, just to refamiliarize myself with your case and the circumstances that led to your probation. I've gotten some information here today also about how probation's gone and your violation. I do think that the recommendation by Agent Mertz is an appropriate recommendation. I follow that. The court is going to sentence you to 12 months in the Crawford County Jail. The credit that you're entitled to is 253 days. The court, by statute, is not required to take into account any other time it may have served. And frankly, I think probably deserved. So I'm not going to give credit for the time I'm entitled to. But I am going to give you every day that you're entitled to here. It's 253 days. The court is going to preserve any outstanding fines or costs and discharge you unsuccessfully from your probation. You do have the right to appeal the sentence, and Mr. Thompson is going to provide you with some papers that explain to you what your appellate rights are.
Mr. Belba, you're going to initial here. This is the case that you received it. You're going to end up with 2 of these copies. If you wish to file an appeal, you would use these 2 copies. You can both ask for an attorney and file an appeal with them. The first deadline is in 14 days. You don't have to make your decision right now, but those are the documents.
Any challenges to this morning?
No.